Welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the court and the opportunity to ask questions. In the case of Hashim Thaçi, Kadri Veseli, Recep Salimi, and Jakub Krasniqi, the fourth witness called by the Thaçi defense testified this week. James Covey served as principal deputy to the special representative of the UN Secretary General for Kosovo during the relevant period of the indictment. Mr. Covey completed his testimony today. In the same case, on the 26th of September, the trial panel granted a defense request to be relieved of its disclosure obligations in relation to limited redactions that were applied to 3 documents. These redactions were applied by the entity that provided the documents. Under Rule 107 of the Rules of Procedure and Evidence, if the specialist prosecutor has custody or control over information which has been provided on a confidential basis and solely for the purpose of generating new evidence, such information and its origin shall be protected under the law and shall not be disclosed without the consent of the provider. In this instance, the trial panel noted that after the prosecution's renewed request to the provider of the documents, the provider declined their full disclosure on the 12th of September 2025. Besides our regular update on the status of the cases today, we would also like to take the opportunity to note a number of incorrect statements in the media recently about the judicial proceedings and to clarify a few matters. First, Mr. Thaçi and his co-accused in this case were all arrested on the basis of arrest warrants and an indictment that was confirmed by a pretrial judge. They were charged in line with the law before their arrests. The pretrial judge confirmed the indictment after he found that the evidence provided by the prosecution had established a well-grounded suspicion that the accused had committed the war crimes and crimes against humanity charged in the indictment. Second, the reason why each of the 4 accused in this case have been detained so far is because the judges have assessed for each of the accused that there is a risk of obstructing proceedings and committing further offenses, in particular against persons who have testified or are due to testify before the specialist chambers. For each of the accused, the judges assess every 2 months whether detention is justified and proportionate, applying the law and international human rights standards. In the case of Mr. Thaçi, part of the reasoning in recent detention decisions relates to indications that Mr. Thaçi may have revealed confidential information about upcoming witnesses to his visitors in the detention facilities and may have instructed them to unlawfully influence these witnesses' testimonies. Finally, when it comes to fair trial rights, it is important to emphasize that the court has mechanisms in place to ensure that the rights of the accused in all of the cases are respected, including the possibility of referral to the specialist chamber of the Constitutional Court, and through the regular process of appeal, whereby the decisions of one panel of judges can be challenged before another panel of independent and different judges. Continuing with an update on the proceedings, in the case of Hashim Thaçi, Bashkim Smakaj, Fadil Fazliu, Isni Kilaj, and Hayreddin Kuçi, related to the alleged unlawful influencing of witnesses, the prosecution notified the pretrial judge on the 29th of September of the matters of fact agreed to by the parties in the case. In order to make the proceedings more expeditious, the rules provide that the judge shall record any matters of fact or law agreed on by the prosecution and the defense ahead of the trial. As a reminder, the pretrial judge in this case announced that she intends to transmit the case to a trial panel in the first half of November 2025, subject to the Court of Appeals panel's decisions on pending pretrial motions.